Back to Advocacy Alchemy with Professor Ross. We're going to watch a video. It's called Test Dirty After Deadly Accident and Get Revoked. This is by Old Squishy Gardner, Court Watch. He does many videos on this Judge Cedric Simpson out of Michigan. Sometimes they can be quite funny, and sometimes they can be quite serious. This is one that is in between. He's quite serious with this defendant, and also he's quite serious with the person afterward. He deals in brief with a sovereign citizen at the end, and we'll watch this one all the way through. I have the law that we're potentially going to be looking at here that's in violation. Michigan reckless driving causing death penalties. All right, in Michigan, bring this a little bit closer like this. All right, it says in Michigan, reckless driving causing a fatality is a serious offense, according to Michigan compiled law, section 257.626. A person who operates a vehicle in a willful or wanton disregard for the safety of persons or property and causes the death of another person is guilty of a felony. The penalties for this offense include imprisonment for not more than 15 years. That's a stiff penalty. A fine not less than $2,500 or more than $10,000. Additionally, the court may impose other sanctions such as vehicle immobilization or forfeiture, and the driver's license will be revoked for at least 1 year. Let's look at the levels of felony offenses in Michigan. Maybe I should have said it better. Okay, it understood what I was saying. Once again, we're using Search GPT, but you can use anything. You can use Google search, you can use Yahoo, you can use whatever search engine you wish to find out what are the classifications of felonies in Michigan. We're going to work with Michigan law since this judge and this courtroom and this whole endeavor and incident is from Michigan. All right, you have several classes of felonies. All right, you have M2 felonies. These are the most serious, including first-degree murder, and carry a maximum of life in prison without parole. Class A felonies, these include second-degree murder, so on and so forth. Class B, these carry a maximum term of 20 years in prison. C, up to 15 years in prison. So we know that our charge, it says not more than 15 years. So we know this is a C felony. All right, you have D felonies that do up to 10 years in prison, a fine of up to 20. E felonies, up to 5 years in prison. And then you have F, G, and H felonies, and they say they have lower maximum sentences. All right, Michigan also has a 3 strikes law for habitual offenders, where the 4th felony conviction can result in a mandatory minimum prison sentence of 25 years. So that's serious. All right, with that, let's go ahead and let's move into this one, and let's see what Judge Simpson has to say. Move this back, so this is there.
It's gonna be a long conversation. Where did you throw it away?
There was a little bit left. I used
I know.
it. I disposed of the tray.
You what?
I used it, and I.
Oh, you used it. Then okay, so it didn't stay on the tray.
And I disposed of the tray.
Yeah. You take it any way you want to.
Ready, Judge.
Yeah, Johnson, I'm on behalf of the people.
Court shall feast your assistant public defender, Mr. Walter LaCroix. Mr. LaCroix, please state your name for the record. Walter LaCroix. Thank you, Judge. I have spoken to Mr. Edmonds about this case. It's going to do some further look at the matter to see where we stand in terms of an offer. We're asking just for an adjournment for a couple of weeks of the PCC, and then I need to address his. It's not a bond violation yet, I don't believe, but it's a bond report where Mr. LaCroix given permission to test in Genesee County. He signed up for a program, DNA testing in Genesee.
Okay, let's pause for a second here. Now you see the judge has a Zoom going here so he can talk to some people that are in jail or defendants. All right, this person is out of order. All right, smoking while on camera. While you're on camera, you are in court. Okay, so everything still applies. You have to wear clothes in my home jurisdiction. Okay, so in my home jurisdiction, if you're in court, whether you're appearing in person or by Zoom, you have to be dressed appropriately. You can't be doing things that you wouldn't be doing if you came to court. All right, and we have a little courtroom here as an example. But if you were to come to court, and the judge was sitting up there with his people, you wouldn't come to court and smoke in one of these chairs here or on one of these benches back here. That'd be against the rules. So I don't know if this is actually the bondsman, and we'll find out in just a second. This is the defendant. This is the public defender, and he announced that when he first came up and started speaking. All right, so he's speaking on behalf of his client, this gentleman here, and he's saying he's having a bond report, bond BOND report. We have typed that in here to see what that means in Michigan, Michigan. All right, bond report and pretrial release rules. In Michigan, the bond process and conditions for pretrial release are governed by several statutes and court rules. Here are the key points. Entitlement to a bail. All right, we have the Michigan section. The Michigan, you know what does MCL mean? All right, Michigan complied laws. Okay, that's what MCL means there. All right, so MCL section 765.6, a person accused of a criminal offense is entitled to bail, except as otherwise provided by law. The court must consider the seriousness of the offense, public protection, the accuser's criminal record, and the likelihood to appear at trial when setting bond. All right, so the court may allow for a 10% deposit bond where the accused posts 10% of the full bail amount. Alternatively, a surety bond can be posted, often by a bail bondsman, for a fee. All right, so look, some of the conditions of pretrial release are prohibiting the defendant from committing further criminal offenses, restricting contact with certain individuals, imposing travel limitations or curfews, requiring some regular reports, prohibited use of alcohol or controlled substances. That can be one of your bond conditions. I don't know if he does automatic bond conditions, depending on what the circumstances were for the charge. I'm sure the judge has already addressed these when he was initially set free. All right, so you could be required to surrender your passport, to continue to seek employment, remain in the custody of a responsible community member who agrees to monitor the defendant. All right, let's see where we're at with this one.
The county, that program did not release testing results to the community corrections unless he was
Well,
positive.
hold on a second. That's not what I have. Do you have his progress report?
The one that I have, I do have a progress report. I don't
From August 28th?
I don't believe that's the date. Let me check.
Mr. Allen?
Mine dated August 28th.
In terms of his testing, I have so he's here on an operating while intoxicated.
All right. Notice he said August 28th. I will note that today is just the 30th. So this video was just taken from Court Watch. So you guys over there do an excellent job of watching the courts and bringing these videos to the public. All right, I'll rewind it and we can continue forth.
Mine dated August 28th.
In terms of his testing, I have so he's here on an operating while intoxicated causing death.
That's correct, Judge.
All right, and on August 20th, after his arraignment, what day was he arraigned?
I believe he was arraigned on the 16th.
So then he got tested on the 16th he was arraigned. He went to test there. He tests on August 20th, and he's positive for cocaine.
Correct, Your Honor. I'm aware of that.
Then, on the 22nd, he didn't appear for his testing.
That was when I was setting up to be tested in Genesee County. I didn't have to test again because I had just tested. I was just signing up to test in Genesee County. And I called the lady down here to let her know right away.
All right. Let's go back a moment, because I don't think he's been before me.
I don't believe so, Judge. Just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he.
All right, that's an excellent question. All right, why is he testing positive when he was just arrested for operating a motor vehicle while intoxicated and causing death? All right, intoxication. Now, notice they haven't said what his intoxicant was, or actually, I think they're going to get into that in just a second. So let's let him keep. He's gonna cook. He is cooking.
Use cocaine, Your Honor. Obviously. I don't think he's.
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he is not any longer.
What?
My understanding is he is not any longer, but he previously was. He began testing, transferred that testing to Genesee County per the instructions he was given at arraignment. He's been testing there, but they are not reporting the results here unless he is positive. They have not called him to test this week. He's called them twice a day to go test. They have not called him, so he went over today to community corrections and tested here. And he is going to change if the court allows
He
him.
tested here today?
Here this morning.
What is it? Do we have results on that?
I don't have it.
I don't have anything yet.
All right. Usually, when what they're talking about now is usually when a person is on probation or some sort of supervision requirement, and they have to come in and test regularly. What happens is that they will have to come in and submit a sample, whether it be a urinalysis or whether it be hair follicle or even a nail bed test. Now, the nail bed test and the hair follicle test, as I understand, are a little bit more expensive. So they may be using whatever cost-effective measure, which is probably a urine sample. All right. I have put in here let's take a look at this. How long does cocaine remain in the system for a drug test? Now, this is not for certain, but this gives us a general time period. Now, I've heard this before from different officers and probation officers, so this question is asked many times in court so that it's on the record in a certain person's case. Because, and why you say things are put on the record is for in the event that a person wishes to file an appeal, what happens is a full transcript of each hearing will be produced, or the appealable thing. If you're appealing your whole case, every transcript from every hearing will be sent up to the appeals level to be reviewed. While you go back over certain common knowledge things like how long does a sample still test negative, it's because many times the appeals judges, you don't know who's going to read it. You don't know how many appeals judges are at that level. You don't know what their prior experience is with dealing with drug cases, any of that stuff. So you want to lay out a very clear record of everything. So even though you may know the answer as an advocate, or you may know the answer as whatever your role is in the courtroom, you want it stated on the record so that it's going to go up and they can see, okay, while they're reading the record, oh, usually a diluted sample or a contaminated sample will show up at this range of times. All right, let's see what this says. All right, it varies depending on the test, and that's usually common knowledge. Depending on what type of test, these more expensive, the hair test goes out farther and looks back. Nail tests look back even further. Blood tests look back a certain period of time. Urine tests look back a certain period of time. Cocaine can be detected in urine for 2 to 4 days after use. For a chronic user, it can be detectable for up to 2 weeks. All right. Blood test. Cocaine is detectable for up to 12 hours. And it says its metabolite, this word here, it's a medical term, can be detected for up to 48 hours. A saliva test. Cocaine can be detected in saliva for up to 2 days after use. A hair test goes back 90 days or longer, depending on the length of the hair sample collected. So that's interesting. That's good common knowledge to know, everyone. All right, let's keep going. I will wind it back just a bit and we'll go forward. All right, so the gentleman standing up over there is the prosecutor. All right. He asked the question that we were asking. All right. He's snorting cocaine again, snorting or smoking. I don't think he said which one yet, but the judge asked, what was the underlying offense? What type of intoxicant do you have in the system? Cocaine. All right. So you're still using the exact same thing you got arrested for, and somebody got killed.
Right. He's charged. I just want to make sure. so I have it clear in my head.
You do.
He was charged with operating while intoxicated, causing death.
That's right.
The intoxicant in that charge is cocaine.
That's right.
He's in arraigned, so now he knows what he's charged with. He's told to go to community corrections. When he gets to community corrections, mind you, 4 days later,
He tests positive.
he tests positive for cocaine.
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray.
Oh man.
and-
Let's say that again. All right. He's trying to get a clarification here because now while the judge is trying to get a clarification, if you're ever in court and you're on this side trying to defend yourself and a judge is trying to get clarification, all right, that's when your stomach should start to drop because he's trying to get clarification to determine whether you're going right to jail or not. Okay? Listen closely.
He tests positive.
He tests positive for cocaine.
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray
And then
I
you
threw it
just
away.
smoked it.
I threw it away.
You threw it away?
I had some in my house
How's that
on a
work?
tray and I disposed of it.
Where did you throw it?
So you see they paused for a second here and you saw him whispering. You see everybody over here is laughing and the courtroom people are laughing. This is what it's like to go to court, everyone, okay? Now, if you're just a lay person, someone coming in to learn about the law, how things work, welcome. If you want to be involved in this system on a daily basis, whether as an officer, whether as a court personnel, whether as an officer of the court, meaning an attorney, a judge, a prosecutor, public defender, when you go to court, it's open like this. Everyone's listening to your business get transmuted. It's getting put on the record and it's being recorded down. When you say something that's silly, people are gonna laugh. And when they get home, they're gonna tell everybody, hey man, this happened in court. And after that happened, I knew the judge was serious and I was just hoping I could make it home and not go to jail. Let's go back. This face.
How's that work? Where did you throw it?
She works for him.
It's gonna be a
right
long
here.
conversation. Where did you throw it away?
There was a little bit left. I used
I
it.
know.
I disposed of the tray.
You what?
I used it, and I.
Oh, you
Oh,
used
tray.
it. Then okay, so it didn't stay on.
All right, so the pause, and when his lawyer was whispering his ear, he probably told him with some explicatives mixed in, some cuss words, hey, don't lie to the judge right now. Everything is being recorded. Do not lie. If you used it, tell him you used it. Because you just tested positive. You wouldn't test positive for whatever kind of test they're using there if you weren't using still.
The tray, but
And I disposed of the tray.
yeah. Yeah. Okay, well.
And since then, I haven't touched it since.
What's that?
Okay, he probably stopped using because he was coming today.
Copies.
Yeah?
I'm printing them now.
You're printing them. Mm. So somebody needs to answer for me, why was he using after being arraigned
I mean, obviously,
on this charge? And why was he using?
I don't
have my theory wrong.
Yeah, I don't think there's any answer
Oh, darn.
to satisfy the court as to why.
And by the way, you're still using.
Honestly, I don't see how.
Oh, really? Hold on. You know what? The thing.
All right, that what he just had her print off to the side was the results from his test that he took that morning. All right, so don't go to court ever. If you have to go and appear in front of a judge for any kind of charge, never tell a lie, okay? Because though a person may, and this guy's not old, but sometimes judges are elderly and old, and you think you might can get one over. You don't know the person that you're in front of and what they, how quick that person's mind is. No matter what they may look like on the bench, they might look like they're sleeping, but they will remember everything that you said. Do not tell a lie. Only tell the truth. And consult with your lawyer before you start talking in court, because everything is being recorded. I think this is maybe his assistant here, and the person recording everything may be sitting down here, the stenographer in the old days, and now just a court reporter now, and someone who's recording the whole events that are happening. And as we see, this is all being recorded on this Zoom too. This is not the official record, but this is out here for everybody to see.
I hate more than anything is when somebody lies to me.
Okay.
Honestly,
Oh,
right.
darn.
Satisfy the court as to why.
And by the way, you're still using.
honestly, I don't see how.
Oh, really? Hold on. You know what? The thing I hate more than anything is when somebody lies to me.
Honestly, I'm not.
Okay. Well, just make sure that it has to be consistent. It must be just possible. And that you let this being signed.
Counsel, approach briefly. You want to see this? That's my copy, though. Yeah, this is the one he took today. No, not at all. We need all of this.
All right, understand that. Here, let's pause for a second.
From 2 to 7 days later.
And once again, I'll have the link to this full video in the description below. Take the time, like the video if you've been in this long, listening to me talk and lecture about the different ins and out of a courtroom hearing. But also, whenever a judge says counsel approach, he's talking to both attorneys, both sides, and he wants to discuss something with them. This shouldn't be heard by the whole room. Now, when that happens, everything is still being recorded. And when someone orders a transcript to be made, or when someone appeals a hearing, still everything will be communicated. But before then, on that document, it will say, probably in parentheses, sidebar. Or it will say, and that's what the meaning of a sidebar is. And but he's communicated with them outside of the hearing of this whole gallery out here, or gallery, however you want to, everything beyond this bar. The public, he don't want the public to hear at large what he's communicating with them.
Yeah. 7 days later. And a little bit that he threw away.
Okay.
Go ahead, I'm sorry. I'm messing up your story.
Oh, I know. Okay. But all I've done is I've used it in the chair that I saw. I've used it in the chair. That was it. When it's second, well, no, I didn't know. Okay. Well, we'll tell them that, but you know, exactly. I know. I didn't know I'm doing this. I'm the truth. Okay.
To answer your previous question, Judge, why?
Oh, he's positive for cocaine.
Judge.
And so that we know.
Thank you, Judge. And to answer your previous question as to why he's still using after being arraigned,
Sure.
clearly he has a problem, Your Honor. There's no answer I can give you that can justify use of cocaine after arraignment when it's an illegal. He doesn't have any type of special license to allow him to use cocaine, Judge. So clearly has a problem. He is willing to fix that problem when he's testing there. He is working, and he did voluntarily come here today and take a test. So he's asking you to not say that, right?
No.
No, you have to stay.
All right, anything else?
All I can say, yo. What me say?
Well, let me tell you the truth, okay? My cousin doesn't allow anything. It's possible. I have friends at my mother's house where cousin's house to do work down there, okay? Because I'm gonna eventually reside down at cousin's house.
All right. So, to the positive test, Your Honor, I have no explanation aside from what he already told you.
Which positive test?
The
first one or this one?
The first positive test.
Oh,
The
okay.
explanation he gave you is that he used it and then threw away the tray. After he was arraigned, after he was ordered not to use, have no explanation, Your Honor. He'll just ask for mercy from the court on that, and he is willing to get any treatment that the court would allow him to take place.
Except that he can't follow the court's order. I don't know how he's going to do treatment. And the other thing is, he doesn't test when he's supposed to test.
This judge.
So it seems to me I have two options. I can let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine, and kill somebody else. I'll let you go. Not doing it.
Understood, Judge.
Defendant's bond is revoked. Defendant remanded to the Washington County Jail. I'll set his hearing September 12, 2024, 9 a.m. for probable cause.
All right, so you heard that his bond was revoked. A bond revocation means that the amount that he would have put up to allow him to stay out and free is now forfeit. So now he needs to turn himself in, or now an arrest warrant will issue, and he'll be remanded into the custody of the jail. We have some contempt pulled up here. All right, in Michigan, contempt of court occurs when someone disobeys a court order or acts in a way that shows disrespect for the court. Here are the key points. You got civil and criminal contempt. Criminal contempt involves actions that disrespect the court or its authority. It can include disruptive behavior or disobeying court orders. Sanctions include fines, jail time, or both. All right. Now, a bond revocation is not necessarily a contempt, but it's like a contempt because you didn't follow the court's orders. There was already an agreement of what the punishment was going to be. When you have a bond, the agreement is that if you fail to do the things outlined for this bond, the conditions on this bond, then the punishment is that you'll have to wait in jail until your case is over. All right, so that can be quite life-changing, depending on how much time it takes to complete the case. All right, let's look at this other one. It's only about 4 minutes, and it's a sovereign citizen or someone trying to make an argument like a sovereign citizen. I'm not going to label this person as that, but she comes with some of the language. Basically, a sovereign citizen, once again, is a person who does not feel that the laws apply to them, and they due to them believing that they are sovereign, or they should be treated as a sovereign entity, one that's not subject to the laws of this land, All right? That's not going to work. All right? Even citizens of other countries will have to submit to these laws as long as they are present in this country or in that state. Every state you go into, you have to abide by their laws. If you fail to abide by their laws, then your permissions to be a lawful citizen will be revoked. With that revocation, once again, you'll be remanded into the custody of that locale's jail. That's simple logic. All right, let's watch.
912.
912.
Thank you, Judge.
You're welcome. Court does call the case. People versus Jade Lathan.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the Principal Jade Lathan, and I'm making this special appearance at District 15, Michigan.
All right. So first of all, there are certain terms that people who work in the legal field have heard before, and once they hear them, they kind of know what direction a person is going in. First of all, she has a public defender, and she's doing way too much talking, so he knows what the deal is, and you see he has come forward, put his chin onto his hands. Watch his facial expression. Look to this side of the screen and watch him as you hear the words Moorish American.
Court of law.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the Principal Jade Lathan, and I'm making this special appearance at District 15, Michigan.
Did you see him suck his jaws in? It was sort of almost like the action of sucking one's teeth, like, okay, I got one of those again. All right, let's see how he deals with this.
Of law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker 15400 and AA Condoleezza 02002 claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely.
You see him, he had to look over and say, all right, where are you reading from? Now he's going to try to give some advice because he's noticed that the judge is looking around up here. He's not paying attention anymore. And he just threw somebody else in prison. So once again, we're watching from a place in the future from this event. We're watching this happen. This happened a couple days ago now. All right, this lawyer, I don't know if this is his first case of the day with this judge or if this is the 5th case, but he just saw how the other case was handled. So this public defender who's been assigned to this client is trying to advise his client, hey, you might want to slow this down and let me speak for you instead. Let's see what he's going to say. We'll wind it back just a little bit. Watch him now and watch when he begins to try to interject.
When I am not a criminal. Officers Morgan Parker 15400 and AA Condoleezza 02002 claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I have also not disturbed the peace, and I have on file with the public defender, Kenneth Overwater, right here to my left, a character letter from my former teacher proving that I've always been well-behaved, a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no...
All right, so once again, I don't know if this is a motion day, but the thing to keep in mind, everyone, I always say the street is not the proper place to argue your case. Once you come to court, there are certain procedures that are in place and certain hearings that are specified for when you are to make an argument. All right, so there's a certain practice involved. Hence why you have professionals and why you have lay people, amateurs. You have pro se litigants, ones who choose to represent themselves. All right. Here, this potentially is not the day for this argument. This is not a motion day, and all motions have to be submitted to the other side so they have an attempt and the opportunity to respond back before an argument is made in front of a judge. Okay? When you deprive one side of that ability to hear what the argument is before we get here in this professional setting, it's going to cause your motion to be denied many times. All right? Now I say not all, but many times that will cause a denial, or you won't receive that relief at this point in time. You will have to wait until some other day when you'll be able to come back and make an argument, and the other side will be able to make an argument, and then the judge will make a decision based on hearing evidence from both sides or theories of the case from both sides. Let's continue forth and let's see what happens.
No history of violent offenses, which is the truth, and I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied two main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These two things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to explain that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people.
All right, so he's answering toward her motion. So first of all, he's talking about the speedy trial nature. All right, speedy trial, and we'll look up what that means in Michigan. But speedy trial usually means a case should happen within 1 year's time. 365 days from the time that a case is filed. Let me get my phone back on here. All right. Speedy trial. Michigan speedy trial. All right, you have a right to a speedy trial as a part of the Sixth Amendment. All right. Under Michigan Constitution, it's Article 1, Section 20. You get the same right. And it's been compiled into the laws at Section 780.759. All right. This rule ensures a speedy trial and resolution of all court matters. It prioritizes criminal cases over civil ones and mandates the release of defendants on personal recognizance if incarcerated for over 180 days for felonies or 28 days for misdemeanors, unless the court finds a high risk of non-appearance or danger to the community. All right, let's talk for a second from just right here. All right, from this section right here, talking about the term of incarceration set at 180 days. Now, to keep in mind, this 180 days, the person we heard about from just a moment ago, the gentleman with the suspenders on, who just got revoked, this does not apply to him. He's automatically determined to be a high risk of danger to the community. Why? Because he fails to even do the basic requirements of the court. He's going to be considered a danger to the community. He is no longer in this. His bond is revoked until further notice. Now, he may be able to, depending on the length of his case, request again from his attorney to file a motion to set a bond or for a reconsideration of his bond revocation. But at this point in time, he is just in the custody of the Michigan jail that he's at. All right, certain periods are excluded from the 28 and 180-day calculation, such as delays from other proceedings, periods of incompetence, and adjournments requested by defendant or prosecutor. So he's saying, he's made the statement that the defense, meaning that woman herself or her counselor, has requested some of these continuances. So that time tolling goes against the defense. To toll time means to stop the clock, and toll is spelled T-O-L-L, like toll roads. And when we say it's tolling, when you toll the time and the time is tolled, the clock no longer runs. That 1 year time period no longer runs.
Review of the file that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr.
All right, you deny her
Just
motion
be
to
asking for
dismiss.
adjournment of the probable cause conference.
And this was simply a probable
Any
cause
objection from the
conference.
No, Your Honor.
Let's take,
I've offered a misdemeanor offer of 1 count of attempt resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. In this matter, thank you.
Thank you, Your Honor.
all right, so let's bring this forward and let's talk for a second about, all right, the procedural history of a case in Michigan. All right, so we'll type that in.
On January 28th, 2024.
No, we don't want to go to the next video. All right, I'll get that out the way, and let's deal with this. Procedural history of case in trial court what are the different hearings called? All right, so you see key hearings in Michigan trial court procedure. All right, so this is a part of the criminal procedure. This is instead of the police investigation side of criminal procedure, this is the court phase side. All right, procedural history. The procedural history of a case outlines the sequence of events and legal proceedings that have taken place from the initiation of the case to its current status. All right, this includes the filing of the complaint, the service of process, the filing of the answer, discovery, motions, trial, post-trial motions, appeal. The types of hearings. You got the preliminary hearing, determines if there's enough evidence to proceed to trial. The arraignment. The defendant is formally arraigned or charged and enters a plea. This is when the charges are read out and the defendant usually pleads not guilty and requests a jury trial. You have your motion hearing day, addresses specific motions such as to dismiss the case or exclude evidence. Excluding evidence in my home jurisdiction is done through a motion to suppress evidence, whether it be written or spoken testimony. Evidentiary hearings resolve disputes related to the admissibility of evidence. The trial, that's the main proceeding where the case is presented and a verdict is reached. Sentencing hearing. If the defendant is found guilty, the court imposes a sentence. Post-trial hearing addresses any motions or issues that arise after the trial, such as appeals or enforcement of the judgment. All right, all important things. All right, so once again, thank you so much for hanging with me to the end. This is Advocacy Alchemy with Professor Ross. Remember to like and subscribe. I have other videos out and we'll continue to produce content and build up a library to help you as the average citizen or as an attorney or as any other person working in the legal field to understand what happens, whether it be out in life, whether it be in a courtroom, what are the laws that apply, how are these things usually viewed. All right, once again, thank you so much for watching and taking this time out of your day. You all have a good morning.